private?
This is not a legal system. This is what I said. Sorry?
The national one.
The national legal system. Public and private law are sectors, are parts of the national legal system, of the legal system of a state. So we are used to deal especially with the legal system of a state, or also European law, which is the legal system of already an international organization, a specific legal system of an international organization, and this has certainly something to do with international law. International law is separate, so it's something totally autonomous from the legal systems of states, from the other legal systems we know, and it is different. So the legal system that we call international law is very different from Italian law, from French law, from Indonesian law, from Vietnamese law, from the legal system of any other state, or from the legal system of the European Union. Although the legal system of the European Union, to a certain extent, depends on international law. It depends certainly on international law. But per se, it is something which is different from international law. So international law indicates this legal system, which is different from all the other legal systems, and it also indicates the norms belonging to that legal system. I can say, for example, the Geneva Convention of 1949 relating to the prisoners of war is international law. So, because it contains rules of international law, norms belonging to international law. So law is always an ambiguous term because it can indicate a whole legal system, the Italian law, or it can indicate a specific piece of legislation, a specific part of the legal system. Okay. Why do we have an international legal system? The explanation which is often given is that in Latin terms, I'm sorry if I will sometimes use Latin words, but we will always translate them. For those who have no knowledge in Latin, I use sometimes Latin words because they are used in law, they are used also in international law, but you are not meant to use Latin words. You can just use English words to express the content that we are expressing in sometimes in Latin. Anyway, the expression is ubi societas ibi ius, which means wherever there is a society, there is a law. So according to this theory, every kind of society is regulated by some laws. So this is true for the national society, the society which is contained within a state and which is formed by all the individuals belonging to that state. This is a society which has its law, and it is the law of that state. And it is true because it is true for the international society. Considering the international society, the society formed by states, by all the different states. So also this is a society because states are living together in the same world and they interact with each other, and therefore there is a law. there are the rules regulating this society. Now, I'm not totally sure that this is always necessarily true, that wherever you have a society, you have a law. What is sure is that wherever you have a society, you have some rules of behavior that are followed by that society. For example, if you consider a family, we can also say that a family is a small society. And each family follows certain rules, but it is not a law. It is not considered as binding, although it may be considered sometimes as binding within a family to behave in a certain way. But anyway, it is not a law in a proper sense. But what is certainly true is that ubius ibi societas. Where you have a law, you have a society. So wherever there is a legal system, that legal system is there because it is regulating a specific society. And this is true for international law. It is true for national legal systems because, as mentioned, the state law is the law regulating the national society composed of all individuals belonging to that society. It is true for international law. International law is a legal system, and it is the legal system regulating the international society. The international society is basically the society of states, the society which was born among states. Nowadays, as we will see, other actors have entered the scene. Which other actors? What do you think are the other actors that entered the scene of the international society?
International organizations.
Exactly, international organizations, very important. Since the 20th century, international organizations have become very important actors in the international society. Just think of the United Nations or the European Union and many others. And what other actors? Yes, please. NGOs, yes and no. We will deal with the problem of NGOs. We may certainly say from a factual point of view, especially some big NGOs play a very important role in the international arena, but only to a limited extent we could say they are actors, formally actors of the international society regulated by international law. Other actors which have emerged, even less than NGOs, no, lobbies cannot be considered as, because when we say actors, we mean something which has a formal relevance, not only a relevance in the terms of influence. Of course, a lobby can play a big influence on how things are decided, but actor has here even a formal content. Any other idea? Yes, please. Absolutely, but regional organizations are international organizations. There is no difference. When we say international organizations, it can be a universal organization, it can be a regional organization. Any other idea?
Sorry?
big firms, big companies. Yes and no. It is the same as for NGOs. Certainly big companies play very important roles in the world, but only to a very limited extent. They can have a specific relevance for international law, and this is a problem that we will mention it. Yes, please, at home.
Terrorist groups?
It could be, especially in certain cases, if they reach a certain level of organization and action. We will go back to this. You are not thinking of the simplest actor we may find. Individuals. Individuals have become, to a limited extent, but they have become actors relevant in the international society in recent decades. So the current international society is more complex than the international society we could find in the past. Often you will hear, we will also talk often about the international community. Now, when we say the international community, we are expressing the concept according to which there is a certain common feeling and common action on the part of the members of the international society, especially states, which is debatable, of course. How much can we talk about an international community today? Is there really an international community, or is there only an international society? Because if we say international society, we do not express any judgment. You can't have a society with each member of that society not collaborating with any of the other members, although a society implies a certain interaction. But if we say international community, and often international law speaks about the international community, we refer to a certain common intent or common objectives and collaboration among the members of the international society. Okay, so the international law, as the law of the international society, is essentially the legal system which governs the relations among states. As the national legal system, for example, the Italian legal system, is the system governing the relations among the Italian citizens, or anyway individuals subjected to the authority of the Italian state. In this case, it is the relations among states. As we will mention, I don't know if we will mention it today, but if it is not today, it will be during our next class. The current international legal system was born we may say more or less around the 17th century, 16th, 17th century. Now, what was the name which was given to that system at the time? It was a new legal system, and therefore people didn't know how to call that legal system. And they called it jus gentium, which was a term used by the Romans, the ancient Romans. The ancient Romans divided the jus civile and the jus gentium. Jus civile was the law regulating the Roman citizens, while the jus gentium was the law regulating the laws, the norms, which were common to all people, also people belonging to other entities, also foreigners. So in some way, they were norms considered by the Romans to be based on reason, on nature. This jus gentium. Coming back to what I was saying, the people didn't know how to call this new legal system, so they called it by using the legal language of the Romans, because the Romans had elaborated the most advanced legal system. And so they used that language because it was the only legal language they knew. But as you can understand, jus gentium, so a law which is common to all nations. It is written, jus gentium, this one, jus gentium, which means the law of the gentes, of the peoples. So like say, we could say today, some legal norms that are common to the Italians, to the Brazilians, to the Russians, to the South Africans, to all peoples around the world. But as you can understand, this term cannot properly express international law, because international law is not a law which is common to all people. It is a law which regulates the relations among states, which is something different. It is situated at a different level. Therefore, it was also expressed as jus inter gentes, and this is already more appropriate. Inter gentes means among the peoples, a law among the peoples. Although it is not really among the peoples, it is among the states. But okay, it was a first step. But at the same time, in various languages, the people continue to express, to indicate international law as the jus gentium. So the French translation is the droit des gens, the law of peoples. In English, it was the law of nations. In German, it was the Völkerrecht. And it is still the Völkerrecht. So Germany has maintained, the German language has maintained the old denomination, the law of peoples, which is equivalent to the jus gentium. But the jus inter gentes at a certain time became the jus, the law among the nations. the international law. International law means the law among the nations. The first theoretician to use the term international law was the English philosopher and jurist Jeremy Bentham. In 1780, he was the first to use the terms international law, and these terms have been adopted by many languages. And unfortunately, I cannot give you examples in all languages, but droit international is now the way in which the French express this law, derecho internacional in Spanish, direito internacional in Portuguese, diritto internazionale in Italian, международное право in Russian. Well, the Russians will be able to tell me if it is the correct translation of international law. I think it is. It is.
Yes, it is.
Yes, international among nations. Thank you. And so most languages, I don't know, I cannot tell you about Chinese. I'm sorry, I'm ignorant about the translation in Chinese, which is a shame because I should know, but anyway. So I don't know exactly what is the content of the denomination in Chinese. Anyway, most languages now adopt these terms, international law, the law among nations. In fact, the most appropriate denomination would be what? What do you think could be the most appropriate denomination? Any idea? If it is the law regulating the relations among states, how could we call it? Yes, exactly. Interstate law would be the most appropriate. Now, of course, as I mentioned, there are not only states, but also other actors. But anyway, states remain the most relevant actors in the international society. So interstate law would be the most appropriate name, as it is not the relations among the peoples or the nations as such, but among the states. But anyway, now the name which is used for this legal system is international law. Okay, what is the object, or what are the objects of international law? Because the relations among states is something very nice, but what does it mean? So the question is for you, what is the object, or what are the objects of international law? You can just make examples.
Peace among nations.
Thank you very much. Certainly peace among nations. Okay. What else?
To achieve cooperation, maybe.
Yes, but this is very broad. I would like to have more specific examples given by you. The seas, the territories, yes, certainly. The borders, all these are issues concerning international law, yes.
Maybe economic regulations.
Sorry, once at a time, please. Let us hear for a moment. Yes, please.
Girls first.
The forests? Did you say forests?
No, I said girls first to let the girls speak.
Okay. I said maybe economic regulation.
Yes, economic regulation. Yes, I mean, there are certainly a big number of economic rules. Certainly, when we say relations among states, there are many important economic aspects in those relations, and they are also subjected to the rules of international law. I couldn't understand what Giuseppe was saying. Anyway, if you said forests, yes, also forests can be an object of international law. If you didn't say forest, but also forests can be an object of international law.
No, I said before to promote trade.
Okay, thank you. Trade, yes, absolutely. Absolutely, thank you. Other opinions?
Perhaps conflicts among states and which laws to apply when a dispute arises?
Yes, when there are disputes among states. Okay, thank you. Yes, please. Thank you. Well, your colleague says a substitute of all diplomacy. Well, diplomacy is a part of international law. I mean, it is regulated by international law, so old or new, but it is certainly regulated by international law. But what I would like to drive your attention on is that international law is not only concerned with the typical objects of diplomacy, so peace and territory and borders. This is absolutely true. Even the big issues of trade among nations, absolutely true. But there are even much more limited objects of international law, much more specific objects of international law. So can you think of much more concrete, much closer to us objects of international law, please? You're referring to the immigration, to refugees and to all these issues. Yes, absolutely. Thank you.
Maybe the respect of human rights.
Exactly. Thank you. So if, for example, the police is using force to repress a protest in the street, there may be issues concerning international law. I would like, because before we just considered the Guardian of today's Guardian, but if you think of recent events, which you have read on newspapers, on the internet, which you have heard on television, recent events, very recent events. Can you tell me about recent events which may be of concern for international law? Yes, please. The situation in Afghanistan, certainly, no doubt about it. Thank you. Exactly, absolutely. The treaty between the treaty is an issue of international law per itself, as of itself, but the treaty between Australia and the US and the UK on the provision of nuclear submarines to Australia. But these are still big issues. I want more limited issues which may be of concern for international law.
The killing of Giulio Regeni. It could
Absolutely, Giulio Regeni, yes, but this is less recent. The police in the US using the force against people trying to go to the US from Mexico in these days. I mean, yes, absolutely. This is an issue which concerns international law. The promotion of development of states is an issue of international law, yes. To guarantee equality among states, yes. Banks, yes. Supranational organizations, well, these are anyway international organizations. So yes, criminal networks, but this is maybe referred to my question before, which was the question concerning the actors. But banks are not actors. We will come back to these issues of the actors. So even criminal networks are not necessarily actors of the international society. COVID mandates. What do you mean by COVID mandates? Fernanda, what do you mean by COVID mandates?
I meant more in the sense that there's been protests in France and Italy and also in the US, and how this might reflect in international law.
Yes, the protests, yes, may be of concern for international law. The alleged kidnapping of the Israeli boy, Eitan, who was the only survivor of the Motarone tragedy. Yes, absolutely. This is a case which is regulated by rules of international law. The Green Pass is something which is of concern for international law. In fact, once again, as I told you when considering the newspaper before, it is probably easier to mention cases which are not of concern for international law than to refer to all the cases which may be of concern for international law. Who can tell me something which is not, which would not be of concern for international law?
Elections?
Elections, at least to a certain extent, is something which pertains to the, we may say, the domestic jurisdiction of a state, something which means is totally under the control of a single state. However, when could elections be of interest for international law? Yes, there can be cases in which elections do not respect international rules which may be binding for that state. For example, if there are issues of the regularity of those elections and the state is bound by obligations concerning the regular keeping of democratic elections. I want to make a premise about our course. We will be dealing with many cases and cases concerning one or the other country. This is with no prejudice against any country. We will speak maybe much more of some countries and less of some other countries. You will hear a lot, for example, concerning the United States or other countries, just because there are international cases which concern more certain countries with respect to other countries. Of course, in many situations, there are different views concerning those cases, but what I want to be clear is that we're dealing with that we try to deal with that in a scientific way, so considering these cases under the lens of international law, and this is without any prejudice against any specific country. There are countries which are the source of more concerns about international law than others, but of course, and there may be free debate among us if we deal with certain issues, and you have different opinions. You may, of course, take the floor and say your opinions. Another case I see is the setting a dispute between two Italian citizens which took place in the Italian territory. This would be an issue not of concern for international law. It depends. It depends. Because how is the settlement of the dispute dealt with? Because if the dispute is settled in a regular way according to the law, yes, probably this is not of concern for international law, but it depends on the case. Do you think that the issue of the prisoner who got a weapon which was sent with a drone to the prisoner, did you hear that? He was in prison and he received a weapon with a drone. That happened in an Italian prison yesterday. Is that of concern for international law? Well, no, the drone did not come from abroad, but it could be. I mean, there are many rules of international law, so certainly we may say the state has an obligation to keep the safety and security within its prisons. So even this kind of case could be of concern for international law. Okay, let us come to a different issue. When we say international law, we will deal with international law, which sometimes is also called public international law, not because it is public law. It's something totally different from public law, from constitutional law. It is international law, a law which regulates the relations among states, basically. But when it is called public international law, which is sometimes the case, it is in order to distinguish it from private, the so-called private international law. Private international law is also called, in the Anglo-Saxon systems, is also called conflict of laws. anyway, private international law is a domestic law, is a part of national law. And it is the law, it is called private international law because it rules on the relations between individuals and companies, also legal persons. Please, 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 your microphone off. Thank you. If you don't take the floor, please leave your microphone off. So, it is regulating relations between individuals and companies, relations possessing transnational elements. What are relations possessing transnational elements? Sorry? I cannot understand the... Yes, transnational companies, yes. Yes, absolutely. Thank you. Other relations, transnational, possessing transnational elements. Yes, a dispute between two nationals of two different countries. Yes, please. Double citizenship in certain cases. The marriage between an Italian citizen and an Angolan citizen. Any kind of relationship concerning international families. Or any kind of commercial relationship which is trans-border, across the border. So the private international law is the law which will determine, first of all, whether the local courts, for example, if we are in Italy, whether the Italian courts have jurisdiction to deal with the case. Maybe the Italian courts will say, no, this is something which happened in France, so we don't have any jurisdiction. If they say, yes, we have jurisdiction, the second question is, which law has to be applied? Because as it is a transnational situation, it could be regulated by the Italian law, but it could also be regulated by the law of another state. So private international law tells you which is the law regulating this issue. But it is Italian law which tells you which law would regulate this issue. For example, the national law. If it is a divorce between two German citizens, the Italian law could tell you, the Italian private international law could tell you this issue is regulated by German law, the national law, so German law in this case. Third issue to be solved by private international law is, for example, you have a judgment which has been rendered by a Russian court on a certain case. Can this Russian judgment be recognized and enforced in Italy. So the issue has already been decided by the judge of another state. Can we give effects in Italy to the judgment given in that other state? All this is private international law, and it is part of domestic law, of national law. However, also private international law issues may be an object of international law. Why? Of public international law. Why? Because there are international conventions regulating issues of private international law, which means that the international convention will oblige states to regulate in their domestic law private international law issues in a certain way. So as an effect of that convention, you will have a uniform private international law among the states parties to that convention. And in the European Union, you have now private international law is practically dominated by EU rules. So it is no more an Italian issue or a French issue. It is very much regulated by EU rules. But these, of course, are something different from international rules. Yes, but you're right, but this is a question of, so your colleague was saying there are EU rules, it is called the so-called Dublin system, which establishes that refugees need to be accepted by some rather than others EU countries, but some of these EU countries have refused to accept the refugees they would have been bound to accept under EU law. But this is not so much an issue of private international law, this is an issue of EU law, but this is a substantive issue. Because it is not a question of the private international law only defines what is the applicable law. It does not regulate the content of the obligations. In this case, we are talking about the content of some obligations concerning the acceptance of refugees in one country. So it is not an issue of private international law, it can be an issue of international law. Public international law. Anyway, we only considered private international law to say we are not going to deal in our course with private international law. You should know what private international law is, and that private international law is something different from international law, even private international law may be considered by rules of international law, such as private law may be considered by rules of international law. You have conventions concerning how private law or civil law, however you call it, has to rule on some issues. Anyway, we will only deal with international law, which is sometimes called public international law. I don't know if all this is clear to you. Do you have any question? Everything is clear, I guess. Okay, so thank you very much for today. This is it for today. And we will continue, we will come close.